All right. We're now calling the case of Marks v. Sonny's Rooftop Bar. My name is Judge DeCamp. Scoring judges, please look to the two buttons on the lower left of your screen and turn off your audio and video. These should remain off until the trial ends. You should also have your video set to hide all non-video participants. This means that the only people on the screen right now should be the advocates and me. And folks, if you happen to see me look off to the side, it's not that I'm ignoring you. I have another screen there. I promise I'm listening. With that, will the attorneys, starting with the plaintiff, please make appearances?
Good afternoon, Your Honor. My name is Reed Smith, and I'm here on behalf of the plaintiff, Mrs. Ethel Marks, who's representing her late daughter, Jessica Marks. Today, I'll be joined by my co-counsel, Mr. Jude Bueno. And now you won't see or hear from Mr. Bueno today, but he'll be running the technology, helping time the proceeding, and running all of our exhibits.
Understood. Thank you. Defense?
Yes, Your Honor. Good afternoon, Your Honor. My name is Madeline Levin, and today I represent Sonny's Rooftop Bar. I'm joined by my co-counsel, Ms. Becker.
Good afternoon, Your Honor.
Afternoon.
While you won't be able to see or hear Ms. Becker, she'll be assisting me with the technological components of today's trial.
Great. Thank you. Before we get to openings, are there any pretrial or housekeeping matters we got to talk about?
Yes, Your Honor, I do have a couple procedural questions. First, may we assume that all objections made are outside the presence of the jury?
Yes.
And may we have permission to freely share exhibits on the screen after they're entered into evidence?
Yes.
And one more thing on that note, Your Honor, I do intend to show the jury one exhibit during opening statements that are not in evidence yet, but I do have a good faith basis to believe that they will be offered shortly after the opening statements on the direct examination of Morgan Levin. I just wanted to let the court be aware, and Ms. Levin, of that fact.
Ms. Levin, do you have anything to say about that?
Yes, Your Honor, we'd ask that opposing counsel only elicit that testimony, that foundation for that exhibit in their direct examination. There's no foundation yet on the record. I'm not sure what the exhibit is, but we don't have any foundation for it. And so at this time, it's not admissible. And we ask that opposing counsel not show it to the jury in opening statements.
Your Honor, may I respond?
Well, why don't we just get everything out in the open since we are constructively at sidebar? What's the exhibit?
It's a redacted version of Exhibit 3. It's literally just a picture of Jessica Marks. I'm happy to share it on screen at this time.
No, if it's just the picture of Jessica Marks, I'm fine with it. But I appreciate the arguments from both of you. Any other procedural things we got to talk about?
The plaintiff is ready to proceed, Your Honor.
Okay. Defense?
Yes, Your Honor. We'd like to invoke Rule 615, which constructively sequesters all witnesses with the exception of Sonny Mehta, our party representative.
Okay, that'll be granted. Anything else?
Yes, Your Honor. If you can't see or hear me at any point, please do let me know. And with that, we're ready to proceed.
Great. I think I have another instruction to give everyone. We're now going to hear opening statements from each party. Everyone should make sure that they are now in speaker view. That button is in the upper right of your screen. And counsel, please remember to mute your audio. And as a courtesy, I would also like it if you turn off your video as well while the other attorney is giving opening and closing. Okay. With that, I'm going to shut up and stop being visible. And plaintiff counsel, whenever you are ready to give your opening, please do.
Your Honor, may I rearrange my camera setup real quick?
Absolutely fine. Sir, you're muted.
My apologies, Your Honor.
Hey, no problem. Whenever you're ready.
May it please the court, Ms. Levin, and members of this jury. The signs were there. They just didn't care. It's 11 p.m. on the night of March 24th of 2019 at a rooftop bar in Malibu, California. The owner of the bar has been going back and forth all night long to the same young woman's table, serving drink after drink, round after round. The young woman has 5 drinks within 45 minutes of arriving at the bar. The signs are there. She is obviously intoxicated. She's slurring her words, talking loudly. At one point, she even stumbles down the stairs. The owner of the bar, she sees all these signs and she knows she should cut her off. But even though the signs were there, they still served the drinks. They continued to serve drink after drink until that young woman was too drunk to drive, too drunk to make reasonable choices. This young woman's name was Jessica Marks. She was 19 years old. She should have never been served a single drop of alcohol in the first place. And unfortunately, within minutes after leaving the bar that night, Jessica Marks crashed her car off the road and into a ravine. Jessica died. And that's why we are here today, to hold the bar that served those drinks responsible. Good afternoon, members of the jury. My name is Reed Smith, and I represent the plaintiff in this case, Mrs. Ethel Marks. You see, Mrs. Marks has filed this lawsuit on behalf of her late daughter, Jessica Marks, against the bar that served those drinks, Sonny's Rooftop Bar. Now, we all know it's illegal to serve alcohol to a minor, but as the judge will tell you, if a bar serves alcohol to a minor who's obviously intoxicated, the bar is responsible if that person gets hurt. And we'll prove that's exactly what happened here. That even though the signs were there, they still served those drinks because they just didn't care. As the plaintiff in today's case, it's our burden to prove 3 things are more likely true than not. First, that Jessica Marks was a minor. Second, that the defendant served her alcohol while she was obviously intoxicated. And third, that this alcohol caused her death. Now, no one will dispute that Jessica Marks was a minor, or that the defendant served her alcohol while she, or that this alcohol led to her death. The only question you have to answer today, members of the jury, is whether the defendant served her alcohol while she was obviously intoxicated. And we'll prove to you that they did. Because during today's trial, you'll hear from a woman named Morgan Levin. Now, Miss Levin was the best friend of Jessica Marks, and she was with her that night at the bar. She'll tell you about all the drinks the defendant was serving her, ranging from beer to hard seltzer, to a whole bottle of wine and hard liquor shots. She'll tell you how Jessica Marks was slurring her words, talking loudly, and at one point, even stumbling. Members of the jury, if all that's not enough, you'll get to see for yourself, because we have a video of Jessica taken at the bar just an hour before she died. Members of the jury, throughout this trial, you'll realize that the signs were there. The defendant just didn't care, and that makes them responsible. That's why at the end of this trial, I'm going to stand here and ask you to find the defendant liable for wrongful death. Thank you.
Thank you, Mr. Smith. Ms. Levin, whenever you're ready.
Yes, Your Honor. She controlled her choices. It's March 24th, 2019. Jessica Marks is standing at her car door. Keys in hand, she pauses. She's been drinking, but she tells herself she'll be fine. She gets behind the wheel, and Miss Marks makes it to where she's going. Sonny's Rooftop Bar in Malibu. Members of the jury, you'll learn that moment in Miss Marks's car, it happened hours before Miss Marks ever set foot in Sonny's bar. And you'll learn that when she did, Miss Marks made a similar set of choices. At the end of a night of drinking around midnight, Miss Marks is again at her car door, keys in hand, and again she pauses. Reassures a friend she's gotten pretty good at driving after a big night. But this time, Miss Marks doesn't make it to where she's going. She's in a car crash, and she dies. Members of the jury, before I say anything else, let me say this. Jessica Marks's death is a horrible tragedy. A young woman lost her life too soon, and nothing that happens today is going to change that. But you've been tasked with determining who is responsible or liable for Miss Marks's death, and as devastating as it is, we'll prove Miss Marks controlled her choices, and those choices contributed to her death. Good afternoon. My name is Madeline Levin, and today I represent Sunny's Rooftop Bar. We're here because the plaintiff has brought a wrongful death suit. They've taken on a burden to prove that Miss Marks was served alcohol while obviously intoxicated. They'll fail to meet that burden. Because you'll hear today from the owner of the bar herself, Miss Sunny Mehta. Miss Mehta will tell you she served Miss Marks a reasonable amount of alcohol, 5 drinks over the course of 3 hours, and that Miss Marks never exhibited any signs of intoxication. But we've also raised what's called an affirmative defense. We've taken on a burden to prove that Miss Marks contributed, at least in part, to her own death. That's why you'll be asked to focus on Miss Marks's choices. The choices she made before she got to the bar, the choices she made after. You'll learn she chose to drink. She chose to drive. That's why, at the end of today's trial, we'll ask you to find Sunny's Rooftop Bar not liable. Thank you.
Thank you very much, Ms. Levin. Okay. Now, before the plaintiff calls its first witness, I will kindly ask everyone to please switch to gallery view. That button is in the upper right of your screen, and that will allow you to see the attorneys and witness at the same time. Okay. Well, with that, plaintiff counsel, do you have a witness you'd like to put on?
Your Honor, the plaintiff would like to call Miss Morgan Levin.
Okay.
May I proceed?
You may.
Please state your name.
Morgan Levin.
Why did you tell the jury a little about yourself?
Yeah, of course. I'm a student at UCLA studying biology. I just finished my sophomore year, but before that I lived in Pennsylvania.
Did you know a woman named Jessica Marks?
I did. She was my best friend.
Would you recognize a photograph of Jessica Marks if you saw her today?
Of course.
Your Honor, at this time, we'd like to show Exhibit 3 on a screen. It's a redacted version of Exhibit 3 for purposes of identification.
That's fine.
Ms. Levin, is this an accurate depiction of Jessica Marks as you remember her?
Yeah, it is.
Your Honor, at this time, we offer Exhibit 3 into evidence.
Any objection?
No objections to that redacted version, Your Honor.
Very good. It's in evidence.
Now, Ms. Levin, when was the last time you saw Jessica Marks?
That would be March 24th of 2019. It was the day she passed away.
What were y'all doing that day?
Well, she had picked me up and we went to her Airbnb and we decided to go out to a bar, you know. It was her last day of spring break and we wanted to have a good time.
All right, well, Mr. Bueno, let's get a timeline on screen of that night for the jury. Now, what time did y'all get to the bar that night?
It was 9 p.m.
Do you remember what time you left the bar?
11:45.
Mr. Bueno, let's reflect that on the timeline. Mr. Bueno, let's reflect. Oh, it's on the timeline. Thank you, Mr. Bueno. Now, Ms. Levin, I'd like to talk to you about whether you documented any photographs. Did you happen to take any photographs that night?
Oh, yeah, I took plenty. I was going to post them to Instagram later.
Would you recognize those photographs if you saw them today?
Yeah, I would.
Your Honor, permission to share exhibits 11 through 16 on screen for purposes of identification.
That's fine.
Ms. Levin, are these an accurate depiction of those photographs as you remember them?
They are.
Your Honor, at this time, the plaintiff offers exhibits 11 through 16 into evidence.
Ms. Levin, any objections?
No objections to exhibits 11 through 16 pursuant to stipulation 17, Your Honor.
Okay, very good. They're all in evidence.
And Your Honor, both parties have stipulated to the timestamps these photographs were taken as they were gathered from the metadata in Ms. Levin's phone. So we ask permission to reflect those times on the photographs now.
And you said that's stipulated to those timestamps?
Yes, Your Honor.
Very good. Yes, go ahead.
Now, it looks like, Ms. Levin, in exhibits 11 and 12, I see a bottle of wine in 2 glasses, but I don't see those in exhibit 12. Can you explain why?
Yeah, of course. I was still working on my first glass, so Jessica had the rest of the bottle.
And how many glasses did Jessica have?
4.
I also see a can there in exhibit 13. Would you explain that?
Yeah, that's a White Claw that Jessica had that night.
So by 9:42 p.m., how many drinks had Jessica Marks had?
That would have been 4 glasses of wine and 1 White Claw.
Well, Mr. Bueno, let's go back to that timeline. Let's reflect those drinks on there. Now, after this, did Jessica Marks appear to become inebriated?
Oh, yeah, I'd say so. She's getting a little louder. Her words were a little slurred, and she even fell.
Did she appear to become inebriated in front of any employees of Sunny's Rooftop Bar?
Yeah, it was actually Sunny that she fell on.
You're referring to Sunny Mehta, are you?
Yes, I am.
Now, how did Sunny Mehta respond?
She said, "Whoa, Frankfurt, I think we may need to cut this one off."
What time was this again?
This was around 10 o'clock.
All right, Mr. Bueno, let's put that on the timeline. Now, this is important, Ms. Levin. After the defendant said, we might need to cut this one off, is that what she did?
No, she never did.
Objection, Your Honor. Speculation. This witness testified that Ms. Mehta never cut Ms. Marks off, and she can only testify to what she observed.
Fair enough. Plaintiff counsel, do you have a response?
Your Honor, Ms. Levin has already testified that she was with Jessica Marks at Sunny's Rooftop Bar that night. That she's giving her opinion and what she observed, that if the owner did not cut Jessica Marks off that night, she's allowed to testify about what she observed, and she didn't observe that. So that's how she's answering the question right there.
I completely understand what you're saying, sir. My issue is that the question didn't necessarily call for that. The question was a bit more broad. And so if you could narrow the question to just be from what you observed, I'll allow it. But for the moment, it's sustained.
And motion to strike, Your Honor.
Sure, that's granted.
My apologies, Your Honor. I didn't quite catch the last bit of your response.
No problem. So what I was saying is that you just asked, did he ever cut her off? What I'm saying is, if you could narrow that a bit to, from what you observed, did the owner ever cut her off? Then that would be more appropriate.
Okay, my understanding. Now, Ms. Marks, you just said that Sunny Mehta said we might need to cut this one off. From your experience at Sunny's Rooftop Bar that night, did Sunny Mehta actually cut Jessica Marks off?
From what I saw, no, she never did.
All right, Mr. Bueno, let's go back to exhibits 11 through 16. Now, it looks like there's 2 more cans in those next 3 exhibits. Is that true?
Yeah, that's
And
true.
who drank those?
That would be Jessica. Jessica drank those.
And I also see a beer. Who drank that?
That was Jessica as well.
So did Jessica drink 2 more White Claws and a beer after that time?
Yes, that's correct. After 10 p.m.
All right, Mr. Bueno, let's go back to the timeline and reflect that. Now, did you take any more documentation of the night, Ms. Levin?
I did. At one point, I took a video.
Would you recognize that video if you saw it today?
Yeah, I would.
Your Honor, may we show exhibit 10 on screen for purposes of identification?
Yes, you may.
Ms. Levin, is this an accurate depiction of exhibit 10 as you remember it?
It is.
Your Honor, at this time we offer exhibit 10 into evidence.
Any objection?
Yes, Your Honor, under 104B, conditional relevance. May I be heard?
Please.
Your Honor, Ms. Marks's behavior in this video is not relevant unless opposing counsel can establish that either Ms. Mehta or one of the other employees at the bar was in the vicinity while this video was recorded or watched this video on the night in question.
May I respond, Your Honor?
You may.
Your Honor, Jessica Marks was a minor at the time of this event. This lawsuit deals with strict liability. Whether or not the defendant knew that Jessica Marks was intoxicated throughout the night is actually not an issue. All we have to prove is that she was obviously intoxicated and the defendant served her past that point.
May I respond to that, Your Honor?
You may.
Your Honor, pursuant to jury instruction 12, the question at hand is whether a reasonable person in Sunny Mehta's position or in the position of one of the other employees at the bar would have been able to recognize that Ms. Marks was in fact obviously intoxicated. And that's why it's essential that opposing counsel first establish whether Ms. Mehta was actually privy to this video and to Ms. Marks's behavior during this video. Otherwise, it's simply not relevant.
I understand your point, Ms. Levin. Mr. Smith, go ahead.
Again, it's not relevant whether or not the defendant had any knowledge of Jessica Marks's intoxication that night. We're offering this evidence as evidence of proof that she was intoxicated at the bar and that they served her drinks after. Whether or not the defendant had any knowledge of that is not an issue.
Then how do you reconcile what you're saying with the actual jury instructions then that a reasonable person in the bar owner's shoes would recognize the deceased as having been intoxicated?
Well, Your Honor, they're not supposed to be serving in minors, obviously intoxicated minors in the first place, but they are trained to look for obviously intoxicated. If Jessica Marks was not a minor, this would not be a strict liability lawsuit. So therefore, Jessica Marks, it would not be an issue. So if Jessica Marks was not a minor, then this would be irrelevant because there would be no foundation that the owners had a visible sight of when this video was taken. But because Jessica Marks was a minor, it doesn't matter whether or not the defendant knew that she was obviously intoxicated. The jury verdict form clearly states that it asks if the defendant served Jessica Marks alcohol while she was obviously intoxicated, and that this alcohol contributed in whole or in part to her death. It says nothing about whether or not the defendant had knowledge of Jessica Marks's level of intoxication. Your Honor, because Jessica Marks was a minor and that this is a Dram Shop Act lawsuit, there is strict liability based on that fact.
Okay, I understand that. Ms. Levin, I'll give you the final word.
Your Honor, looking specifically at the language of jury instruction 12, obviously intoxicated means that when the defendant served Jessica Marks alcohol, Ms. Marks displayed symptoms that would lead a reasonable person to conclude she was obviously intoxicated. And then later, it says that the jury may consider whether Ms. Marks displayed some of the symptoms of intoxication in front of the defendant. Your Honor, what's at issue here is whether Ms. Mehta was able to see Miss Marks's behavior and interact with her to determine whether she was obviously intoxicated. And so without that foundation, this video, Miss Marks's behavior in isolation, is not relevant.
I think that was absolutely fabulously argued by both of you. And that was a lot of fun. Ms. Levin, I'll say that I think all the points you're making are fabulous for cross-examination and for your closing, but I will admit the video.
Yes, Your Honor.
But again, awesome job, both of you. That was great. Go ahead.
And Your Honor, is this Exhibit 10, is Exhibit 10 now admitted?
It is.
All right, let's play it for the jury. Mr. Bueno.
He may need to stop screen sharing and then share again, clicking on the make
My
audio
apologies.
heard button or whatever it is. I know there's some trick with screen share to make it audible.
Try it again.
Hi everyone, Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Ms. Levin, was Jessica Marks acting this way in front of the employees at any other point that night?
Yeah, she was.
And what time was that?
What time was this video taken?
Yes, what time was this video taken?
11 p.m.
And when was she acting this way in front of other employees?
It was before we left. I remember Sunny saying something like, I hope this one's not driving after seeing her.
Mr. Bueno, let's go back to the timeline and reflect all those times on it. Now, Ms. Levin, what was the final shot y'all were served that night?
We had a round of green tea shots.
Now, I understand this might be difficult, Ms. Levin, but what happened after y'all left the bar?
You know, it wasn't even 1,000 feet when Jessica swerved off the road, off the Pacific Coast Highway and into a ravine.
Can't imagine what you've gone through, Ms. Levin. Thank you for your testimony. Nothing further, Your Honor.
Cross-examination, Your Honor?
Yes, just a second though, in case I missed something. Mr. Smith, did you move Exhibit 18 into evidence?
Your Honor, Exhibit 18 was pre-admitted.
Oh, was it? Okay, my apologies.
Your Honor, I don't believe that Exhibit 18 was pre-admitted. It's my understanding that Exhibits 1, 22, and 23 are pre-admitted pursuant to pretrial Order 11.
Okay, then Mr. Smith, could you point me to something that says Exhibit 18 was pre-admitted?
Absolutely, Your Honor. If you go to the police report taken from that night, Exhibit 18 is actually incorporated therein, and Exhibit 23 is pre-admitted.
Understood. All right. Then, Ms. Levin, unless you have anything else to say.
Well, Your Honor, the image itself is not included in Exhibit 23, and so Exhibit 18 is still not admitted, Your Honor, not pre-admitted.
Well,
Your
I mean, I'll just cut this short. I only asked because you displayed the image and I wasn't aware of it having been moved in. In real life, that would have been a no-no, but hey, I mean, it's already happened. I just didn't know if I missed something. So, Ms. Levin, go ahead and cross whenever you're ready.
Yes, Your Honor. Good afternoon, Ms. Levin. Can you see and hear me all right?
Yes, I can, thank you.
Let's start by talking about something you spoke about on direct examination. You showed us Exhibit 10, a video you took of Miss Marks in the bar that night. Ms. Levin, you didn't see Sunny Mehta, anywhere in the room when you recorded that video, right?
Not that I can remember.
And you never showed Miss Meta this video on the night of the 24th, right?
I never showed him.
You never showed any of the bar employees this video.
That's right.
You said you never showed them this video. It was on your phone, right?
That's right.
All right, Miss Levin. I want to go back and talk about the choices Jessica Marks made hours before she walked into Sunny's rooftop bar. You got to her Airbnb between 7 and 8 p.m. that night. True?
Yeah, that's right.
And when you got there, Miss Marks had 2 bottles of wine sitting out.
Yes.
You know, she posted a photograph of those 2 bottles of wine on Instagram. True?
I believe she did. Yeah.
Let the record reflect Miss Becker is displaying what's been pre-marked as Exhibit 5. Miss Levin, this is a truthful and accurate copy of what you saw Miss Marks post on Instagram. True?
It looks like it, yes.
At this time, defense offers Exhibit 5 into evidence.
Any objection?
No objections.
It's in.
Miss Levin, you saw Miss Marks have a glass or 2 of wine that night.
Yeah, I did.
So let me get this straight. Miss Marks chose to drink before she ever set foot in Sunny's bar.
That's correct, yeah.
And then it was Miss Marks who drove the 2 of you to the bar that evening.
Yeah, she did.
Miss Becker, we can take Exhibit 5 down now. Thank you. Well, Miss Levin, let's talk about whether Jessica Marks was visibly intoxicated at the bar that evening. You testified on direct examination. You thought Miss Marks seemed drunk, right?
I did think she seemed drunk, yes.
You were sitting upstairs on the patio that evening.
Yeah, we were.
There were about 10 or 12 other customers up on the patio with you.
I think so, yes, around that number.
You never heard any of those 10 or 12 customers go up to Miss Marks and tell her she should stop drinking, right?
Objection, relevance.
Ms. Levin, why is this relevant?
Your Honor, the question at hand today is whether Miss Marks was obviously intoxicated, meaning that a reasonable person could determine she was under the influence of alcohol, whether other customers at the bar were able to recognize this or were not able to recognize this, makes it less likely that Miss Marks was obviously intoxicated to the reasonable person's eye.
Mr. Smith, do you have an argument besides your strict liability argument?
Your Honor, there's no legal responsibility of these other 10 to 12 people to come over and ask Miss Levin if she or tell her that she should stop drinking. It goes to prejudice against the fact that he didn't cut her off.
I don't think that's what Ms. Levin is trying to suggest. I will overrule the objection.
Yes, Your Honor.
Miss Levin, that's a yes to my question. You never heard any of those 10 or 12 people come over to Miss Marks and tell her she should stop drinking, right?
From what I saw, no.
In fact, Miss Levin, you never told Miss Marks she should stop drinking, right?
No, I didn't.
You didn't take Miss Marks's keys?
No. I really should have, but I didn't.
Well, let's talk about the choices Miss Marks made at the bar that night. On direct examination, you gave us a list of all the drinks Miss Marks had that night. She ordered those drinks for herself, didn't she?
Yeah.
You didn't hear anyone else order for her?
No, not that I know of.
You never heard Miss Meta try to persuade Miss Marks to order more drinks, right?
No.
And then at the end of the night, you offered Miss Marks a ride home in an Uber, didn't you?
Yeah, I did.
She refused your offer.
Yeah, she did refuse.
She said she was,
Objection, Your Honor. I respond to that under Rule 403. This is far more prejudicial and probative against this witness. Your Honor, the second affirmative defense in this case has already been dropped before this trial began. There's no legal duty for Miss Levin here to stop Jessica Marks from driving that home that night. There's no legal duty for Miss Levin to cut Jessica Marks off that night. Whether she stopped Jessica Marks from doing anything that night, she had no legal responsibility, given that the second affirmative defense was already dropped before trial. The only affirmative defense that they're allowed to raise in today's trial is that of Sonny Mates.
Ms. Levin, I think I can predict what you're going to say, but go ahead.
Your Honor, assuming that opposing counsel is objecting to my questions about whether Miss Levin took Miss Marks's keys that night and questions of the like, Your Honor, again, we're only offering this evidence to show that a reasonable person could not determine that Miss Marks was in fact obviously intoxicated. The standard for obvious intoxication is what a reasonable person would be able to determine based on Miss Marks's behavior. The fact that on the night in question, Miss Levin didn't try to take her friend's keys or tell her she should stop drinking indicates that Miss Marks was not in fact obviously intoxicated.
Just so we have it for the record, because there was some confusion as to when you objected, Mr. Smith, what was the exact question and answer that you were objecting to?
It was to the objection about the keys to the line of question.
So we're all talking about the same thing. Very good.
Yes, sir.
In that case, I will overrule the objection, but we'll argue from both of you.
Yes, Your Honor. Miss Levin, taking you back to that moment in the parking lot, Miss Marks refused your offer to take an Uber, right?
Yeah, she did.
She said she was fine.
Yeah.
She said, I've gotten pretty good at driving after a big night.
She did say that.
So when given the choice between taking an Uber and driving herself, Miss Marks chose to drive.
Yeah, she did.
Thank you, Miss Levin. Thank you for your time. Nothing further.
Thank you very much. Mr. Smith, do you have a redirect?
No redirect.
Okay. Very good. The witness can step down. And Mr. Smith, do we have anything else from the plaintiff?
The plaintiff rests their case G.
Okay. Thank you very much. Ms. Levin, do you have a witness?
Yes, Your Honor. Defense calls Sonny Mehta.
Very good. And you can proceed whenever you are ready.
Good afternoon, Miss Mehta.
Good afternoon.
What do you do for a living?
Well, right now I'm back with my family in Louisiana. I'm training in the swamps to fulfill my life's goal of competing in the show Survivor.
What did you do for a living before you started training for the show Survivor?
Well, my parents, they bought me a bar to help teach me people skills. You know, that's important if you don't want to get kicked off the island in Survivor.
And when did they buy you that bar?
A few years ago, when I was in my mid-20s.
Why are you testifying today?
Well, Jessica Marks, she came to my bar a couple of years ago, and she died. I'm here to tell you what I saw that night.
When did Miss Marks first come into your bar?
She arrived at around 9 p.m., I remember.
Did she come in with anyone else?
Yeah, she was with her friend Morgan Levin.
And did you serve the two of them that evening?
Yeah, I like to serve my customers face to face. Again, those people skills.
Let the record reflect Miss Becker is displaying what's been pre-marked as Exhibit 17. Miss Mehta, do you recognize this?
Yeah, that's the receipt I gave Miss Levin at the end of the night.
Does it appear to be a truthful and accurate copy of the receipt you gave them?
Yes, ma'am.
And what time did you make this receipt?
Around 1:45 to midnight, 11:45.
Do you normally make receipts like this at your business?
Yeah, I give them to all my customers when they leave.
At this time, defense offers Exhibit 17 into evidence.
Any objection, Mr. Smith?
Again, this exhibit's already in evidence. It's incorporated through Exhibit 23, which is pre-admitted.
It's admitted.
Miss Mehta, taking a look at the drinks on this receipt, how many did Miss Marks order?
Say around 4, maybe 5.
And how long was she at your bar for?
2 hours and 45 minutes, give or take.
All right, so 5 drinks over the course of around 3 hours. How many drinks did you serve Miss Marks per hour?
Let me see, let me do the mental math here. Less than 2 drinks per an hour, I would say.
Miss Becker, we can take Exhibit 17 down now. Miss Mehta, we talked about how much Miss Marks had to drink. Let's talk about her behavior. Did you hear Miss Levin testify earlier that Jessica Marks tripped down the stairs that night?
I did hear that.
Did you see that happen?
I never saw Miss Marks trip down the stairs that night, no.
Did you ever say, we might need to cut this one off?
I never said those words. Yeah, I don't know where Miss Levin got that from.
Well, was Miss Levin drinking that night?
She did order some drinks as well, yes.
Miss Mehta, let's shift and talk about whether Jessica Marks was visibly intoxicated. Do people drink at your bar?
That's why they come to Sunny's rooftop bar, for the drinks and the view. Yeah.
How can you tell when one of your customers has had too much to drink?
Well, there are signs like the way they look, red, watery eyes, the way they talk, maybe talking loudly, slurring their words, sometimes being incoherent, maybe like the way they move, they might be stumbling around or wobbly. They might even have a heavy smell of alcohol, those kinds of things.
Are you trained to recognize the symptoms that you just mentioned?
Yeah, it's required by the state of California.
And what do you do when you see one of your customers exhibit some of those symptoms?
Well, we have to cut them off. And if they come to the bar already seeming obviously intoxicated, we just won't serve them.
Did you ever cut Miss Marks off on the night of the 24th?
I didn't see a need to, so I didn't.
You say you didn't see a need to. Did you see Miss Marks exhibit any of those symptoms of intoxication?
No, all those things I just mentioned, I never saw those from Miss Marks on March 24th.
Do you know what happened when Miss Marks left your bar that night?
Tragedy.
When Miss Marks left your bar, were you concerned about her safety?
I wasn't. She wasn't showing any signs of being drunk to me. She seemed fine to me.
Thank you, Miss Mehta. No further questions at this time, Your Honor.
Okay. Mr. Smith, you have a cross-examination?
Yes, Your Honor.
Whenever you're ready.
I have a moment to rearrange my camera.
Yeah, take whatever time you need.
Thank you. May I proceed?
You may.
Hello, Ms. Mehta. I'd like to talk about your duties as a bar. You would
Sure.
agree with certain obligations under the law, correct?
The state of California requires us to do certain things.
So you would agree from part of your certification that you got from the state of California, you were trained on these obligations, right?
We have a training every 3 years recognizing when someone is drunk.
For example, you know that it's illegal to serve alcohol to a minor, right?
Right.
And it's also illegal to serve alcohol to anyone who's obviously intoxicated. You learned that too.
Yeah, that's what I said on direct. Yes.
And it's your duty to carefully observe your customers, isn't it?
That's what I do as a bar owner.
Ma'am, you were aware of these obligations on March 24th of 2019, weren't you?
Yes, I was.
She never cut Jessica Marks off that night, did you?
Didn't see any need to. She seemed fine, so I didn't.
I'd like to talk about that because you've said multiple times you didn't see any signs of obvious intoxication in Jessica that night, but didn't you serve her table 7 individual drinks?
I served her several rounds of alcohol that night.
Ma'am, 7 individual drinks, yes or no?
Yeah, I did.
And an entire bottle of wine.
Yeah, it was quite expensive, the decoy red blend.
You're aware that her blood alcohol content after leaving your bar was a 0.16, aren't you?
Objection, Your Honor. 403, more prejudicial than probative. May I
Why is
explain?
that? Go ahead.
Your Honor, while it's true that Miss Marks's BAC was 0.16 at her time of death, what matters is whether this witness would have known whether Miss Marks was obviously intoxicated at the bar that night. And so unless opposing counsel can establish that this witness knew Miss Marks's BAC while she was in the bar that evening, this question has no probative value. It's simply prejudicial.
Mr. Smith?
Your Honor, one of the elements we have to prove today is that the alcohol that the defendant served to Jessica was what caused her death. Her being served so many drinks by the defendant is highly probative as it led to her death that night. Any prejudicial value certainly does not substantially outweigh the amount of drinks that Jessica was served at Sonny's rooftop bar and how that affected her death.
Here's a question I have for you. Is the 0.16 on an exhibit that has already been admitted?
Yes, Your Honor.
So I do tend to agree with Ms. Levin on this point insofar as you have the 0.16 for the point you just mentioned. You can use that exhibit during closing to talk all you want about it. I think it's going a bit too far to talk about this lay witness about BAC specifically. Was this your only question on the BAC?
I have one follow-up question as that relates to Jessica Marks's age and the legality with which she left the bar that night.
Just as an offer of proof, what is your question?
It's asking if it's 16 times the legal limit for someone Jessica's age.
Ms. Levin, do you have any other words? Or would you just rehash the argument you made earlier?
Yes, Your Honor. We do concede that Miss Marks's BAC was 0.16 at her time of death, but opposing counsel is asking this witness to testify to that BAC. This is a lay witness. She would not necessarily have knowledge of how much alcohol Miss Marks consumed and how she specifically reacted to that alcohol. Additionally, Your Honor, opposing counsel asked this in a line of questioning about whether this witness recognized that Jessica Marks was obviously intoxicated and whether her BAC was 0.16 at the end of the night. It doesn't have anything to do with whether this witness in the moment at the bar recognized that Miss Marks was obviously intoxicated. It's what she perceived at the bar that matters for this witness. And so opposing counsel's question is more prejudicial than probative.
All right, here's what we're going to do. Mr. Smith, we're not going to go in with this witness about the deceased's actual BAC because you have that evidence already. What I will let you do is ask her as a bar owner about the legal limits for minors generally, because I don't think that's on the record yet. Does that make sense?
Yes, Your Honor.
Okay, then very good. I'll sustain the objection in part and we'll keep going.
And motion to strike opposing counsel's previous question and the witness's answer from the record?
No, that won't be necessary. We'll just move forward.
Now, Miss Mehta, I'd like to talk about how many drinks you served. You already told us you served her 7 drinks and an entire bottle of wine that night. You're aware that she died just 10 minutes after leaving your bar, aren't you?
I served her table those drinks. I don't know how many she had, but I'm aware of that, yes.
You're aware she died 10 minutes after leaving your bar?
Tragedy. Yeah.
Ma'am, are you aware that she was drunk after leaving your bar?
Now I am. At the time when she was leaving, she didn't appear like that to me.
So even though she was ordering drink after drink at your bar that night, You're still telling this jury that she wasn't obviously intoxicated?
I can only tell you what I brought to her table. I don't know what she drank herself that night, but she
Ma'am,
seemed fine to me as she was leaving.
Ma'am, you would at least agree she became more inebriated over the course of the night, right?
I didn't see her show any signs of drunkenness the entire night. She seemed fine to me the entire night.
So all you saw was a perfectly sober Jessica Marks.
I can only tell you what I saw. Miss Marks, she seemed fine to me the entire night.
Redirecting you to my question, you would describe her as perfectly sober. Those are your words, aren't they?
Yeah, she seemed fine to me.
Okay. Let's watch video. Your Honor, we're putting Exhibit 10 on screen to play for the jury. It's already in evidence.
Go ahead.
Mr. Bueno.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Ma'am, that's what you would call perfectly sober?
I wouldn't call that perfectly sober, but that's not the way I saw Miss Marks acting that night.
Well, hang on. You're testifying you didn't see her acting the way you did in the video. Am I understanding that correctly?
Right, that's not how she appeared to me at all that night.
You're where this video was posted at 11:11,
Right, I wasn't there when that video was taken.
but you were still serving her around that time, right?
I served her throughout the night, but I never saw that video being taken. That's not how she appeared to me at all.
Ma'am, you would at least agree she looks buzzed in that video, sure?
In that video, she does, but I don't know her intention behind it. That's not how she appeared to me.
So you maintain you never saw her acting the way she was in the video.
This video is surprising, actually. It's not how I saw her act.
Ma'am, that's not what you told the police that night, was it?
I'm sorry, I don't know what you're talking about.
Mr. Bueno, can we get Exhibit 22 on screen? It's been pre-admitted. Now, let's read a portion. Please read silently as I read aloud, Miss Mehta. I spoke to Sonny Mehta, the bar's owner. Sonny said that Jessica Marks was a typical buzzed girl. Miss Mehta, I read those words correctly, didn't I?
That's what the report says, yes.
So you told the police, so the way you just described this video to the jury is the exact same as the way that you told the police she was acting that night, isn't it?
Buzzed, sober enough, those are synonymous in my book.
Exactly. The way she was acting that night, same way she's acting in that video, right?
As I've said, she seemed fine to me.
Man, you put it as buzzed, didn't you?
That's what I told the police officer, but on it, those words are synonymous to me.
Buzzed, yes, it's the same word. You're asking this jury still to believe, even though you used the same word to describe her that night and the same word to describe her in the video, you're still asking this jury to believe you never saw her acting that way in the video, correct?
Objection, Your Honor, argumentative.
Overruled.
Would you like me to ask that again, Ms. Mehta?
Yes, please.
Even though you described her as buzzed in the video and buzzed to the police that night, you're still asking this jury to believe that you didn't see her acting the way she was in the video. Got that right?
That's not how she appeared to me that night, no.
And redirecting you to my question. Even though you described her as buzzed to the police that night and buzzed in the video, you're still telling this jury you never saw her acting this way.
I can only tell you what I saw, and that's a yes.
Nothing further, Your Honor.
All right, Ms. Levin, do you have a redirect?
Yes, Your Honor.
Go ahead.
Ms. Mehta, on cross-examination, opposing counsel asked you a few questions about how you described Ms. Marks's demeanor to the police. Is buzzed the same as obviously intoxicated?
No, there's a huge difference from being buzzed and from being obviously intoxicated. When you're obviously intoxicated, I would cut you off in my bar. but if you're buzzed, I wouldn't.
And just to clarify, were you in the room when that video was recorded?
No, the video was actually quite surprising to me. That it's not how Miss Marks was acting when I saw her that night. I wasn't in the room.
Did anyone ever show you that video on the night of the 24th?
No, I never saw that night.
Thank you, Ms. Mehta. No further questions, Your Honor. May this witness please be excused, assuming no recross?
Any recross?
No recross, Your Honor.
Very good. Then the witness can step down. Thank you very much for your time.
And at this time, Your Honor, defense rests.
Okay. I take that to mean that we don't have any depot portions that we're reading in this trial.
No, Your Honor.
No, Your Honor.
Great. Then we are now going to hear closing arguments from each party. Everyone should please switch back to speaker view. Also, for my scorers, since both witnesses have completed their testimony, you're welcome to complete the witness portion of your ballot. With that, I'm going to switch to speaker view. And Mr. Smith, you're welcome to start your closing whenever you are ready.
May it please the court, Ms. Levin, and members of the jury. At the beginning of this trial, I stood here and told you that the signs were there. The defendant just didn't care. And that's exactly what the evidence has proved today. That on March 24th, 2019, Sonny's Rooftop Bar served Jessica Marks 4 glasses of wine, 3 hard seltzers, a beer, and a shot of hard liquor. That's 9 drinks in the course of 2.5 hours. 9 drinks that got Jessica Marks so drunk that her BAC was a 0.16. So drunk that she was 16 times the legal limit for someone her age. And yet they're asking you to believe that she wasn't obviously intoxicated? No, the signs were there. They just didn't care. But unfortunately, the state of California requires them to care. Because under the law, they have a duty and a responsibility to cut off someone when they are obviously intoxicated. And when that person is a minor, it doesn't matter whether they actually see them. And because they failed to uphold this responsibility on the night of March 24th of 2019, Jessica Marks died. That's why we brought this lawsuit to you today. Because think about what's happened all throughout today's trial. At the beginning, I told you we had to prove 3 things are more likely true than not. First, that Jessica Marks was a minor. Second, that Jessica Marks was served alcohol by the defendant while being obviously intoxicated. And third, that this alcohol led to her death. Now, no one disputes.
Yeah, it looks as though you're muted somehow.
My apologies. Can be heard now?
I can hear you just fine now, yeah.
Did I get cut off there? Sorry.
I can see and hear you fine now.
Sorry, did I get cut off in the middle?
So I think what happened is, and Ms. Levin, feel free to corroborate this. I think what happened is that out of nowhere you muted somehow.
So in the middle of my speech?
Yeah, you are, yeah.
Oh, okay.
I mean, I don't think this time should be counted against you. I think it was a tech issue. Um,
I have no idea when it started, but a different camera than what's on my computer. So
yeah. Maybe someone could be kind enough to tell you what last sentence they remember you saying, because I don't.
Your Honor, we're happy if opposing counsel wants to begin his statement from the top. We're completely happy with that, Your Honor.
it's
Okay.
perfectly fine with me.
Instead of maybe having to redo the whole thing, maybe there's like a chunk you can get back to? I don't know. However you want to do it. I'm amenable.
I'm not sure how the timing is going to align with where I start back up again. So,
Okay. Well, then for simplicity's sake, especially because I just got a message from a juror whose internet was wonky for a moment as well, why don't we just restart the closing? I think we're doing fine on time. I'm okay with that. It was a lovely closing anyway, so I'm happy to hear it again.
right, I'm more than happy to start over.
Okay.
Okay.
For everyone watching, thank you for your patience and understanding with this process. It's not a perfect science. Whenever you're ready.
Okay. Thank you. May it please the court, Ms. Levin, and members of the jury. Before this trial began, I stood here and told you that the signs were there. The defendant just didn't care. Now, the evidence proved just that throughout today's trial. It proved that on March 24th of 2019, Sonny's Rooftop Bar served Jessica Marks 4 glasses of wine, 3 hard seltzers, a beer, and a hard liquor shot. That's 9 drinks. 9 drinks that got her so drunk she crashed her car off a bridge. 9 drinks in just 2.5 hours. But the defense is asking you to believe that she wasn't obviously intoxicated. No, members of the jury, the signs were there. They just didn't care. And the state of California requires them to care because they have a duty under the law to cut off any person who's obviously intoxicated, to cut off anyone who has been served so much alcohol they are displaying signs that they are visibly drunk. Members of the jury, this applied to young Jessica Marks, underage and being a minor. Even though the defense failed to meet their responsibilities that they had under the law. And Jessica Marks died as a result of it, which is why we brought this suit in front of you today for wrongful death. Now, as a plaintiff, we had to prove 3 things were more likely true than not. First, that Jessica Marks was a minor. Second, that Jessica Marks was served alcohol while being obviously intoxicated by the defendant. And third, that this alcohol contributed to her death. Now, no one stood up here and disputed the fact that Jessica was a minor. No one stood up here and disputed the fact that this alcohol caused her crash. The only thing that was disputed was whether the defendant served her alcohol while she was obviously intoxicated. And we proved to you that they did. Because think back to Morgan Levin's testimony. That night, we got to see the timeline of all the events that unfolded through her testimony. She told you that Jessica Marks had 4 drinks and 5 drinks actually within 45 minutes of arriving at the bar. Unsurprisingly, she was exhibiting all of the signs of obvious intoxication, slurring her words, talking loudly. She even stumbled into no one else but Sonny Mehta. Sonny Mehta even said we might need to cut this one off. And this is important, members of the jury, because after Sonny Mehta said that, he kept serving the drinks. He continued serving drinks that night because he didn't care about his job. The signs were there. He just didn't care. Now let's also think back to the video of Jessica Marks because you've got to see for your very own eyes just how drunk Jessica was that night. You saw the crooked glasses. You saw the slurred speech. You saw her not knowing which drink to grab. Members of the jury, this is all obvious intoxication. And the defendant will have you believe he didn't see her acting the way he did in the video. She did in the video. Because the defendant will tell you that under oath today in trial, he told you he didn't see her acting that way. But let's think about how he described her to the police that night. He said she was buzzed that night. And he said she was buzzed in the video. So why did he use the exact same way to describe her in the video as he did that night? Because the way he saw her acting that night was the way he saw her acting in the video. Members of the jury, regardless of how he defines buzzed, we know that the video is obvious intoxication, and we know that that's a contradiction. Members of the jury, the defendant had a job to do. She just didn't care. But now it's time for you, members of the jury, to do your job. Because in a moment, the judge is going to hand you a jury verdict form in which you're going to have to think back on this trial. And because we've proved that the defendant served Jessica Marks alcohol while she was obviously intoxicated, the first answer to the question will be yes. Which brings us to the next question. Was Jessica Marks' death her own fault? Members of the jury, the defense served her 9 drinks that night. Members of the jury, they stripped her of her ability to make reasonable choices. For those reasons, the answer to that question is no. Now, I'll get up here in a minute and talk a little bit more about that after Ms. Levin. But for now, just remember that the signs were there. Defense just didn't care. Thank you.
Thank you, Mr. Smith. And just as an update, in case anyone's curious, it sounded like all the Zoom breakout rooms had the same issue. So we are not unique. Well, we are, but not about this. So Ms. Levin, whenever you're ready.
Yes, Your Honor. She controlled her choices. It's March 24th, 2019. There are 2 people standing in the parking lot of Sonny's Rooftop Bar. Morgan Levin and Jessica Marks. Members of the jury, we know now that only one of those people made it home safely. The distinction between Miss Levin and Miss Marks, it wasn't how much they ate or how much they drank or who served them. The distinction was the choice they made in the parking lot. Morgan Levin chose to take an Uber. Jessica Marks didn't. She controlled her choices. Members of the jury, in a few moments, this case will be in your hands. You'll have to determine first whether the plaintiff met their burden, and if you find that they did, whether we met ours. Let's start with the plaintiff's case. They had a burden to prove by a preponderance of the evidence that Jessica Marks was served alcohol while obviously intoxicated, and that contributed to her death. They failed to meet that burden. Because you heard today from the owner of the bar herself, Miss Sunny Mehta. She told you she sees visibly intoxicated customers in her bar all the time, and she stopped serving them. Why would Jessica Marks be any different? Now today, opposing counsel asked you to focus on the signs of intoxication that Miss Marks was supposedly exhibiting. But members of the jury, what matters is whether Miss Mehta saw those signs, whether Miss Mehta recognized that Miss Marks was obviously intoxicated, whether she should have been able to recognize that based on her interactions with Miss Marks. So let's look at what Miss Mehta actually saw. Opposing counsel focused a whole lot on a video of Miss Marks. They told you that video was taken around 11:11. They told you it was posted to Jessica Marks's Instagram page. Members of the jury, Miss Mehta never saw that video. Miss Mehta didn't go onto Instagram and see that video. Miss Mehta was not there while that video was recorded. Opposing counsel is asking you to believe that Miss Marks was acting the same way around the bar's staff. But think about it. Miss Marks was underage, fully aware she was drinking in that bar illegally. Wouldn't she have every reason in the world to conceal her intoxication from the bar staff? Because if she'd really seemed that intoxicated the entire night, wouldn't someone else, another customer at the bar, the Uber driver, Miss Levin herself, wouldn't they have stopped her? Members of the jury, the fact of the matter is, it's easy to say now that Jessica Marks was unfit to drive, but to the people in that bar, she seemed fine. And if you find that the plaintiff has not met their burden, has not proven by a preponderance of the evidence that Jessica Marks was obviously intoxicated, that's it. Your assessment stops there, and Sonny's Rooftop Bar is not liable. But say you disagree. Say you think Jessica Marks was obviously intoxicated and that Miss Mehta should have been able to recognize that. Then you have to consider our defense. Did Jessica Marks contribute, at least in part, to her own death? And that question, it's about Miss Marks's conscious choices. The plaintiff asked you to focus on just the 3 hours Miss Marks was in the bar that night. We're going to ask you to look at the full picture. Let's start here. Hours before Miss Marks ever set foot in Sonny's bar, she chose to drink. That means that BAC of 0.16 that the plaintiff told you so much about today, Miss Marks is partially responsible for that BAC because she chose to drink before she ever even met Sonny Mehta. And then you heard that Miss Marks drove herself to the bar. She knew the entire night that she was going to drive home. She drove to the bar. She didn't take an Uber. She didn't call a cab. She didn't have someone else drive her. She drove to the bar. And in the parking lot, Miss Marks followed through on her plan to drive home. She said, "I've gotten pretty good at driving after a big night." Members of the jury, those are not the words of someone who was blackout drunk. Those are the words of someone who was in control. She controlled her choices. And no one is saying that Jessica Marks was a bad person. She was a teenager. She lost her life when she shouldn't have. But the devastation we feel when we think about the circumstances surrounding her death, it can't be reason to turn from the truth. Find Sonny's Rooftop Bar not liable. Thank you.
Thank you, Ms. Levin. All right, plaintiff, I think you may have some time for rebuttal.
If I could ask how much time I have remaining for rebuttal, maybe the bills.
Sure. One minute and 40.
1 minute and 40 seconds. May I proceed?
You may.
Your Honor, please the court. One thing Ms. Levin has tried to tell you is that the defendant didn't know, that Ms. Mehta didn't know, so she's not responsible. That's not true. Because Jessica's a minor, something called strict liability is in play. It doesn't matter whether Ms. Mehta knew that Jessica Marks was obviously intoxicated, and they didn't dispute that fact today. They told us her BAC was a 0.16. They gave you no reason to doubt the testimony of Morgan Levin. None at all. Next, they want you to blame the victim. Members of the jury, no one is trying to say that Jessica Marks made good decisions that night. No one is trying to say it was a good decision to drive that night. No one was saying it was a good decision to drink 9 drinks from Sonny's that night. That's the whole reason the law exists, though, to protect people when they make bad decisions. That's why Sonny's rooftop bar is responsible, to protect Jessica Marks when she has so much to drink that she can no longer make good decisions, no longer make bad decisions. But Sonny's rooftop bar failed to cut her off that night and stripped her of this ability to make reasonable choices. Another thing Ms. Levin mentioned to you is that if you think Jessica Marks is maybe slightly responsible for deciding to drive in the first place, then they win. But that part's not true, because then you go to question 3. Question 3 asks you, who is responsible for what and how much? It asks you to weigh who is responsible. Now, let's think about this. Who's more responsible? Sonny's rooftop bar for blindfolding her and pushing off her cliff, and then getting mad at her when she hits the bottom? Or Jessica Marks, the innocent young 19-year-old girl? I submit to you that that number should be no more than 10% on Jessica Marks and 90% for Sonny's rooftop bar. Find the defendant liable for wrongful death. Thank you.
Thank you very much. I'm going to stop the recording now.